All right, so good morning. We're here on case number 692604, State of Ohio versus Bionca Ellis. She's present in the courtroom this morning with her counsel, Mr. Mack and Mr. Johnson. Good morning.
Good morning, Your Honor.
Our assistant county prosecutors, Ms. Faralia and Ms. Patel, are here on behalf of the State of Ohio. Good morning.
Good morning, Your Honor.
I think all of you know that any case that gets assigned to this courtroom, we set the case for trial as well as some future dates. So I'm going to do that today. Obviously, I'd like to involve all of you so that we have a trial date certain that meets with all of your calendars. Whether that date moves or remains a date on the record or on the books will be determined on how we proceed with the case. It's a 10-count indictment. Aggravated murder is count 1. Counts 2 and 3 are charged in the alternative on the murder counts. Counts 4, felonious assault. Count 5, endangering children. And then count 6 and 7 in the alternative, the attempted murder charge. And then count 8, of felonious assault. I know the parties wanted to have some discussion with the court on the record. What I'd like to do is for Ms. Ellis, just for you to understand, I will have you in the courtroom when we are on the record. If the lawyers are just meeting independently, I will not bring you up. Your lawyers have the opportunity to meet with you in the county jail. In addition to that, the lawyers, I believe you know that occasionally the deputies with notice will allow us an opportunity to meet here, you to meet your client here on the floor, meaning you need to review evidence of sorts, and it might be easier here. So those are something that can be worked out through my bailiff and the sheriff's department if it actually works with your calendars, and I think you both know that as well.
Yes, sure.
In setting this, I'll ask the State of Ohio first about discovery. What discovery is outstanding? If you can give me at least information of when you expect certain discovery, just so that I'm aware of what might be out there. I would say this, that blower above you is running continuously. It has not turned off since it paused for a minute during trial last week. So those microphones in front of you, if you can hit the green button or the button in front, that will turn the green on, and then maybe pull the microphone close to you. Even if you stand, you can put it up. But the button in front, if you can just hit it, it'll carry your voice. So let me hear from the State of Ohio, Ms. Brown.
I believe it's on, Your Honor.
Yes, if your green light's on, you're on. Thank you.
Yes. Good morning, Your Honor.
Good morning.
On behalf of the State of Ohio, Anna Faralia, and this morning, Your Honor, with regards to discovery, some discovery has been transferred over to the defense via the portal. We also have a bunch of surveillance cameras and other miscellaneous information that is in need of a terabyte. So I indicated to the defense attorneys that they're going to need to provide to me an external hard drive. I also have been in contact with the medical examiner's office, and they indicated that I should probably have an autopsy report within the next 3 to 4 weeks with regards to the autopsy report of Julian. So other than that, Your Honor, the State of Ohio is progressing with discovery and turning things over. So we'll continue to do that as they become available to me.
Okay, thank you. Counsel, have you been able to receive the discovery that's been sent? And I'm assuming we'll provide a terabyte for that external hard drive information.
Judge Fernando Mack, on behalf of Mr. Ellis, we have received limited discovery, and it's correct with Ms. Fry has indicated that we're still waiting for those other important items.
Very good. So I'm looking at the calendar, and at least initially, I'd like to set it for a trial. I think we said December 9th is a Monday. And 6 months out approximately, which is within the guidelines for the Supreme Court. Of course, those guidelines can be moved. But I think now, at least setting the date, everybody has a date on their calendar. Is that a date, at least looking on their calendars, is available to all the parties? Is that a Monday, Kathleen?
Yes, it is.
I always seem to be the one, Judge, but that
Yes.
may not work out for my schedule.
Okay.
But there are also some other reasons that may toll the necessity of going to trial quickly in this case.
Okay. And again, I'm not looking to move quickly, I'm just looking to have the date. So why don't we put the 9th down tentatively, and if you want to speak further on some of the thoughts regarding Ms. Ellis, I can hear from counsel. Why don't we put the 9th down as our trial date, Monday, December 9th. We'll go back to November for a final pretrial,
November 7th.
and then November 7th would be a final pretrial. Of course, I'll allow you to continue to make pretrials regarding just the attorneys. If there is a need to go on the record, I'll make sure that I have Ms. Ellis up. Anything further from the state?
Not at this time, Your Honor.
Anything further from counsel on behalf of Ms. Ellis?
No, Your Honor, thank you.
All right, very good. Let me note just one thing that I wanted to note. So before the case was indicted and assigned to the court, a staff member of mine noted that they had attended the wake of the decedent in this case. I indicated to that staff member if they could explain to me how they found themselves at the wake, and if there's some concerns the court should at least put on the record, and so I am going to put it on the record. Staff indicated that their partner had, if I'm correct, grown up with the decedent's father while they were youth, and maybe played basketball, like maybe CYO basketball and things of that sort. My staff indicated they had no interaction with the decedent's parents, including the named victim and the counts that are before me as well, and had never met any of the parties regarding the family. Staff did tell me they went, and that was the first time that they met the parents, was at the wake. So that brief moment. They also told me that they donated to the GoFundMe that somehow might be out there. And so I want to note that. When I became aware of that, I became aware of that before the case was even assigned to me. And so then I felt it at least compelling. I don't know any of the parties, nor have I had any contact with the parties, and nor have I had any discussions with my staff regarding that. But I thought I'd put it on the record. I don't believe there's any conflict. I don't feel conflicted at all. And so I place that on the record for you to take for consideration if you believe that you think there's a conflict with the court. I don't see one, just because I don't know any of the parties. But if you want to take that to your staff or your superiors and have conversations, you can let me know, or if you want to speak to it now.
Your Honor, on behalf of the state, we have no objection. In the efforts of being transparent, the members of the Wood family are related to a staff member in the prosecutor's office as well, and that person will have no contact or anything with regards to this case. So with regards to that, we like to put that on the record as well and let the defense know that.
Very good.
Thank you.
And Mr. Johnson and Mr. Mack, I don't know if there's a concern, or you just take it under advisement, and you could let the court know if there's any concerns that you have, whether we're on the record next time or through motion, or if you want to speak to it now.
Thank you.
Yeah, okay. All right, very good. All right, I'll allow you to pick a future date with my bailiff, and I'll have that date just between the parties. I'll continue to ask that you update the court on when the autopsy report is provided to the state, just to make sure the external hard drive has been submitted as well. Okay?
Thank you, Judge.
Very good.
Thank you,
All right,
Judge.
we'll adjourn. Thanks.